Hello everyone, welcome to the 120 Literary and Jury Charge. We're going to start off with some jury charge and the subject is exemplary damages. Ready? Here we go. To justify an award of exemplary damages, the wrongful act must have been done willfully, wantonly, or maliciously. The mere fact that an act is wrongful or unlawful does not justify such damages. The fact that an act was done maliciously may be inferred from the fact that it was done with insult, cruelty, oppression, or other aggravated circumstances. It has been said that the word malice in this connection implies that the act complained of was done in a spirit of mischief or of criminal indifference to civil obligations, that it must have been done in wanton indifference to the rights invaded. Whatever is done willfully and purposely, if it be at the same time wrong and unlawful, is in legal contemplation malicious. However, inasmuch as it is well settled that exemplary damages may be recovered for a willful or wanton injury, irrespective of actual malice, it seems desirable to use the term malice in this connection in its ordinary popular sense. It is argued that the court violated this rule when it instructed the jurors that if under the testimony of the case they found that such assault was committed willfully and wrongfully, they could allow plaintiff such additional sum as they thought would be proper and right by way of punitive or exemplary damages for the purpose of deterring others from the commission of similar acts in the future. The recovery of punitive damages by this instruction left to the discretion of the jurors. They were not informed that they must return such damages if the evidence showed that the assault was willfully and unlawfully committed. It is contended that the instruction is erroneous because the trial court failed to use the word malicious. We think this contention, if sustained, would unduly restrict the cases in which exemplary damages are recoverable. The authorities very generally permit recovery when the tort is committed with cruelty, oppression, insult, or such gross negligence as to justify the inference of malice as a matter of law. The conditions under which such damages are recoverable are stated in the alternative. All these conditions need not concur. Whatever is done willfully and purposely, if it be at the same time wrong and unlawful, and that known to the party is in legal contemplation malicious. That which is done contrary to one's own conviction of duty, or with a willful disregard of the rights of others, whether it be to compass some unlawful end, or some lawful end by unlawful means, knowing it to be such, constitutes legal malice. Okay, now I'm going to give you some land description. Okay, here we go. Part of farm lot number 45, more particularly described as follows, commencing at a point in the south limit of Elliott Street, as laid down on Registered Plan 643, Town of Ridgeway, distant 4,491 feet northwesterly from the intersection of the southwest limit of Elliott Road and the northwest limit of Main Street in the town of Ridgeway, thence northwesterly in the southwest limit of Elliott Road, 66 feet, thence southwesterly and at right angles to the southwest limit of Elliott Road, 40 feet, thence southeasterly and parallel to the southwest limit of Elliott Road, 66 feet, thence northeasterly and at right angles to the southwest limit of Elliott Road, 40 feet to the place of the beginning. Okay, we're going to finish off this literary speech that I gave in the last class. Okay, so we're going to finish this today. Here we go. Ready? We call upon labor's leadership and labor's rank and file to base their wage demands on the new prospect of a return toward price stability as soon as possible. We call upon business to base their investment and prices on that new economic climate, keeping in mind it is in their private interest to be at least somewhat realistic in their planning and to help build a really strong economy. We call upon all Americans to bear the burden of restraint in their personal credit and purchasing so as to reduce the ever-present pressures that help drive prices out of sight. We are convinced that Americans will answer this call. We are convinced that a new confidence will be felt in this great country when we match the strength of our resources with the strength of our resolution. The dollar you earn should certainly be worth $1. The dollar you save should certainly be worth $1. This is no impossible dream. This is something you are really entitled to. The cost of our living affects the quality of life. Together, we are going to improve the quality of life, and together, we are going to succeed in slowing down the rise in your cost of living. All right. I have some medical for you. This is an article on bypass surgery after 80. All right. Here we go. Coronary artery bypass graft, known as CABG surgery, is often not considered for elderly people with coronary disease because of their risk for serious complications. However, there may be few or no alternatives to CABG for patients whose angina symptoms cannot be controlled with medication. Even though the risks of CABG are high in the elderly, the outlook may be even worse if surgery is not performed. Researchers at Duke University, a major cardiac surgery center, recently reviewed the outcomes of all 86 patients aged 80 through 93 years who underwent CABG there from 2009 to 2011. Most of these operations were performed upon people who were desperately ill. 27% had had a heart attack in the last month, and 84% had angina at rest or during only mild activity. The majority of the patients were taken directly to the operating room from the coronary care unit or cardiac catheterization laboratory because they were too unstable to wait for CABG to be performed electively. These data indicate that most of these procedures were undertaken as last resort measures. Serious complications occurred in 29% of the patients, and 14% died during the hospitalization. In contrast, the mortality from CABG surgery in younger patients is under 2% at many medical centers. However, 86% of these very elderly patients survived the surgery, and quality of life improved dramatically. In general, these patients were too sick to be at home before surgery, but 66 or 89% of the 74 survivors went directly home from the hospital, while the other 8 survivors went to nursing facilities. Those at home were able to care for most of their own personal needs. Women were more likely than men to survive the operation and to have good outcomes. All right. Now I'm going to give you some jury charge, and the subject is contributory negligence, and our brief for that is TREG, TREG, contributory negligence, TREG. All right, here we go. Ready? Ladies and gentlemen of the jury, contributory negligence is a want of ordinary or reasonable care on the part of the person injured by the negligence of another, directly contributing to the injury as a proximate cause thereof. Contributory negligence may also be defined as a failure on the part of a person injured by the negligence of another to exercise ordinary or reasonable care to avoid the injury. One cannot recover damages for an injury to the commission of which he has directly contributed. If the passenger is at fault, whether because of doing something he should not have done, or in failing to do something he should have done, then he cannot recover any damages for injuries he has sustained. If the passenger's negligence has been a proximate cause of his injuries, he cannot recover from another who has also been negligent. But before you can find that the plaintiff is barred from recovery because of his own contributory negligence, you must find that his negligence was a substantial factor which, together with the defendant's negligence, proximately caused the accident. If the plaintiff, in the exercise of ordinary care under the circumstances, should have been aware either that the defendant was unmindful or some danger known or apparent to the plaintiff, or that the defendant was not taking proper precaution in the operation of the car, and the plaintiff failed to admonish the driver or failed to take proper steps for his own safety, and if such failure to admonish the driver was a substantial factor in proximately causing the accident, then the plaintiff cannot recover, even though the driver was negligent. But if you find from the evidence, as the car in which plaintiff was riding approached the place of the accident, the plaintiff exercised the care that a person of ordinary prudence and care would have exercised under the same circumstances with regard to admonishing the driver, then the plaintiff was not guilty of contributory negligence. The burden of proof rests upon the defendant to prove, by the preponderance of the evidence, that the plaintiff was guilty of contributory negligence. And if on this question you find the evidence evenly balanced or preponderating in plaintiff's favor, then you will find that the plaintiff was not negligent. All right. I've got some interesting facts. This is Facts About the Body, Part 3. Here we go. The average person's total skin covering would weigh about 6 pounds if collected into one mass. The average woman's thighs are 1.5 inches larger in circumference than the average man's. Not fair. An average man on an average day excretes 2.5 quarts of sweat. The palms of the hands and soles of the feet contain more sweat glands than any other part of the body. False teeth are often radioactive. Approximately 1 million Americans wear some form of denture. Half of these dentures are made of a porcelain compound laced with minute amounts of uranium to stimulate fluorescence. Without the uranium additive, the dentures would be a dull green color when seen under artificial light. For many years after the Battle of Waterloo, dentures known as Waterloo teeth were sold throughout Europe. These were actual human teeth extracted from the corpses of soldiers on the Waterloo battlefield. They were especially esteemed among denture wearers because most of them came from young, healthy boys. The older a person gets, the less sleep he requires. A child should get from 8 to 9 hours a night. An elderly adult can do well with 4 to 6 hours. The liver is a gland, not an organ. There are 10 trillion living cells in the human body. Tongue prints are as unique as fingerprints. The human body has 45 miles of nerves. The fingernails and the hair are dead. Both are made of a tissue called keratin, which is similar to the dried skin cells that continually flake off the body. Hair and nails, however, originate from living cells. Growth occurs at the base, and new cells push the dead hair and nails upward. Then these cells themselves die to be pushed up and replaced by more from below. While 7 men in 100 have some form of color blindness, only 1 woman in 1,000 suffers from it. The most common form of color blindness is a red-green deficiency. The mouth produces a quart of saliva a day. Human nails and hair do not grow after death. They are simply the last part of the body to disintegrate. The fingernails grow faster on the hand you favor. If you are right-handed, your right fingernails will grow faster. If left-handed, your left. The middle fingernail grows faster than all the other nails. Interesting. All right. And that concludes our literary and jury charge for the 120 class. Have a great day.